I'm trying to, so you guys don't get confused. This is another pit. I'm trying to keep it so you guys understand, because there's gonna be information that you're only talking about. It's those questions on the administrative determination for 64 Friedenberg Lake Road. This information isn't pertinent to the determination that's in front of you. So I don't want you guys to get confused about talking about another pit. So just make sure you keep this in mind when she's providing information. This is a different pit that's owned by it, but it has nothing to do with the 8 questions that you're in front of you to discuss today.
Mark, thank you, but I do disagree with you, and you are part of that, so.
You direct all of your conversation to this board.
Thank you.
Dave?
Yeah, your comment that was just made, what we were told at the beginning, first thing that I saw up here was this business about the McKeever. Okay, it's not relevant. However, there was something that was put up there. You can explain to me why it's not relevant. If there were violations per what we saw up there at the McKeever, if there were violations, therefore there wouldn't be allowance for a permit on the one that we're dealing with.
But that's not what you're here for today.
Wait, I don't understand.
So yeah, and there is
Maybe
a violation.
what I'm trying to understand. Yes, we're looking absolutely at this appeal. And I understand that we're looking at that. But one of the first things that's been brought up here is, how is the McKeever relevant? It's relevant that if there were violations, and we don't know that, we don't have that evidence in front of us. And maybe the court case took care of all that. But if that was in violation, according to that one hard and fast rule, you couldn't give a permit to this next operation.
I can address that.
Okay.
The distinction that I drew at the beginning of this hearing, and by the way, it was the same distinction that I drew in the court case that we faced in Duluth. On one hand, you have a claim that the permit shouldn't have been issued in the first place. Okay? That's the claim that relates to the null and void language in the ordinance that's been cited. There was some mistake in fact, or there was some mistake in law that should have led the Planning Commission to not issue the permit in the first place, or once these mistakes come to light, it's null and void and it should be wiped out.
The original.
Exactly.
Okay.
The cup.
Okay.
That is the claim that we have said, and the state district court has said, is too late to bring. And that is the claim that the planning director did not address in his administrative determinations because it is too late to make that claim. That's on one hand. Okay. That's number one.
I'm understanding that part.
Number two, fine, we've got a cup. Okay, we've got a cup.
Yeah.
Is LTI Holdings in compliance with the conditions in the cup and in compliance with the provisions of the ordinance? Okay?
Yes.
And in court, what we said on that was, you can't just bring that stuff directly to court. We have a process to resolve allegations that somebody's not in compliance with the cup or with the ordinance. And that process is this process. And so that's why we're going through it this way. That's the distinction between the two categories of issues.
But through the court case and such like that, this McKeever is an operational, it's a law, and that's been determined. What I saw, and I still don't understand how it says, if the inspections and such would show this other place is not in compliance, if there, I mean, that's where this comes into play on what's going on there. Because if that person, I mean, that cup has been violated through inspections and are up to snuff, they can't have a permit on another property.
That is a first category issue. That is the permit shouldn't have been issued, right?
Not on the old one. I'm talking about this one, that you can't operate another one if it was in violation. Therefore, it should never have gotten the cup at all.
And I think you're exactly articulating the claim that the cup shouldn't have been issued,
No.
that it's in.
Well,
okay,
well,
then I'm not-
yes,
I'm not-
this one,
Yes,
because you got McKeever and you got
exactly,
64, whatever.
yes,
Okay. Okay, the issue is, this shouldn't have been issued.
correct.
Okay, but we're told not to look at anything that's going on with McKeever, and if there was stuff going on there, it's potentially, this one should never have been issued. And I just saw something up there that the statement was made, any lawyer would agree with that. I mean, if you go back, I mean, I want to clarify stuff as we go along. There's so
Yeah.
much that's going on in this that no permit shall be issued to an operator owner who has not reclaimed a previously approved extractive user is in violation of the conditions of the permit. Okay, so if that previous one, it has a permit, you can't dispute it, it was settled in the district court, but can it be brought up that there were violations at that property that should have not allowed this permit on the new one?
No, that's the claim that was brought too late. That's the claim that needed to be brought within 60 days.
Of what? 60 days of what?
60 days of, I believe it's when the person received notice that the cup was issued back in 2020.
Okay,
So my
This one.
response to all of that is,
it had 60 days and it wasn't done.
correct,
Okay. Thank you.
okay.
Confusion, and I see that, and any lawyer, no, you just stated the 60 days. Thank you. Okay.
Ms. Bell, I apologize for the interruption. We just want to make sure every